Hi, everybody. This is Jeff Fowler with the Apartment Owners Association. And of course, as always, it is great to have you with us today. And we're going to be covering the unlawful detainer process in the city of Los Angeles. And there are so many different landmines, loopholes, and just things that will set your eviction process off or reset it. And so we're going to cover that today. And, we really are dedicated to your real estate success. We're trying to bring you ideas and information that'll help you avoid that kind of setback or give you ideas that'll help you make more money than ever before. And we did a tenant screening crash course. I highly advise you watch that. We did one on the best value for flooring, paint, and blinds. I know some of your units are being turned over right now. And I do want to just mention because I'm still finding so many people that aren't aware of how criminal reports have been impacted at the county level throughout the state of California. Many of those counties, including LA County and Orange County and Riverside and, you name it, even in Northern California as well, they've redacted the date of birth from the county court file on that very first page. And so software that's crawling, looking for information, it's not really able to make a positive identification on John Doe. So is this John Doe your applicant whose name is also John Doe? And so if it can't find the date of birth, social, other information that would positively identify them, then by federal law, tenant screening companies can't show you that. And so this is kind of a de facto way that the state leadership has elected to help people that have been released from prison. And so obviously you still have a duty to provide a safe environment for your tenants, and you want to do that. So what we have now, we've hired a private investigator, and through the AOA tenant screening software, what we do is we run a skip trace, comes up with an address list, right? And then the private investigator takes that list and he'll basically perform a single county criminal search for every county that's listed among those addresses. And then in addition to that, they're looking at the civil as well. So civil will have the eviction records, but it'll also have you'll see how litigious they are, if there's domestic violence or any other civil misconduct. So there's several different places where files that matter are located. It's not all just in the criminal. So that's my point on that one. And the instant criminal report is only going to give you the criminal. It's not going to give you the civil. So anyway, I want to just let you know about Live Investigator. I think you're nuts if you don't use it, honestly. You're nuts if you're in an area where you can use it. So if you're listening today, you're probably in LA and you definitely should be using this. If you've never set up, you're an AOA member, you've never set up the tenant screening, there's an online end user agreement. If you fill that out, you don't even need a site inspection and you can start augmenting your tenant screening with that, or just set up tenant screening totally and with AOA and do it there. Credit checks are $8.50. So you could get a credit check, you could do Live Investigator and pretty much have it covered. Anyway, so yeah, people are so important. Keeping your renters safe is important, and just getting the right people in there is so important. And because we're dedicated to your success, we've uh, gone and gone to great length here to get you information that'll help you um, have the best success possible. And so, as far as information, we do have the AOA $1 million trade show at the Long Beach Convention Center that's coming up in August 20th. And so we want you to come. That is free. That is even free if you're not a member. We will have a toy drive, those toys will go to kids. It's through the uh, Union Rescue Mission that we're doing that through. And so they'll collect those toys and get them to the kids that are less privileged. And so that'll be a cool way that you can help out. And Anyway, so yeah, look, if you're watching for the first time, maybe you're a brand new member and you're on AOAUSA.com, you can keep watching from there. At the top, there's also a YouTube button, and it'll take you right to our YouTube channel. And there we do have a video for new members, on how to maximize your membership. So if you search our channel, just type in the word membership, that'll come up along with a lot of different content. We have well over 100 videos online there. And then, of course, there are some things that are just only for members only, and that's only when you access your member portal that you'll see some of that. And specifically, a couple ones. One that I want to mention specifically is a three-part series about habitability and California Building Code, and just understanding what you need to have, what your building, the shape that your building needs to be in, so that your bases are covered there. All right. And then also, if you're watching on AOAUSA.com, there's the blue help button at the bottom on the right side. And that's a little chat. You can use that to get questions to us. And we will take questions live after the presentation. But hold your questions, because our speaker may cover what your question is. So we're incredibly fortunate today to have David DePauli with us, and he has over 3 decades of experience in California litigation. He's lead counsel at SoCal Eviction Services, and there's another company with that name that is not their company. So they're a brand new company, but he's been in business for over 30 years, and they are focusing exclusively on unlawful detainer cases for property owners. They're not taking it for renters, but for property owners and managers. He's a real estate broker. He's a housing provider as well. So he really brings a unique and practical perspective to this specific topic, because he's dealing with it every day in one way or another. So everybody, let's welcome David. David, it's great to have you with us today.
Thank you, Jeff. I appreciate that. I want to emphasize what you started off with in terms of the tenant screening process. That alone can make your life much easier. There's a lot of ways that tenants, you get professional tenants out there that fly under the radar that may not even have a UD index history, but they're out there in other ways, either in a criminal index or a domestic violence that's going to affect your business as well. And then there's tenants that will sue you after they leave, and it's not an unlawful detainer, it's just a regular civil action, and they'll sue you for everything under the sun that relates to how you run your property. So definitely doing the background check on your tenants is a great way to go. It'll save you a lot of trouble. So today I'm going to do, and thanks everybody for coming. I'm doing the real basic stuff here on understanding the eviction process, and in Los Angeles, which most of you hopefully haven't had this experience, but you probably will in the future. And so this will give you a broad overview of what to expect, and you should also be doing some preliminary planning just in case you end up doing this in the future. So again, Jeff introduced me. My name is David DePauli. I've been doing this for 30 years. I'm a principal at SoCal Eviction Services, and we did form this just for landlords. I get calls a lot from tenants, and I just don't take tenant work. It's just not what we do. We concentrate on landlords. So let me just tell you a little bit about what we're talking about today. So we're going to go over what an unlawful detainer is. So if you're a landlord and you have a tenant, and for one reason or another you need to evict the tenant, you're going to get involved in the unlawful detainer process. Okay, so we're going to talk about that today. We're going to talk about what the legal grounds are for an unlawful detainer if you unfortunately have to get involved in that. We're going to look at the step-by-step legal process for doing that. We're going to look at some of the rights and responsibilities of both landlords and tenants as it relates to that relationship, what you can expect in court if you end up there, and common mistakes to avoid. So let's get started with that. So what exactly is an unlawful detainer? So an unlawful detainer is a legal action that a property owner brings to remove a tenant from a rental property. It's pretty simple. The goal of an unlawful detainer action is to obtain a court order that allows you to physically remove a tenant from a property and recover possession of the property. That's pretty simple. Some people want to avoid the legal process and engage in self-help. I don't recommend that. That's a bad thing. Don't do that. So the unlawful detainer procedure is a way that you go about getting a court order that says, yes, this tenant needs to move and they need to move now. And then you can enlist the aid of the sheriff's department to help you do that. So this process is governed by California state law, by local regulations in LA County, and whatever city you happen to be in. LA City is one of the most stringent cities. They have lots of different rules and regulations that landlords have to follow, and they're pretty stringent, and they're very precise, and you have to dot all the I's and cross all the T's, or you will be out of court if you do bring an unlawful detainer action. So you have to be very careful with that. All right, so let's go through what the legal grounds for an eviction are. One of the most common grounds is the non-payment of rent. This is very basic. You have a lease with a tenant. They're supposed to pay you a certain amount of money every month. They don't. Either they don't pay you the full amount, or they don't pay you at all. Now, the city of LA has a big list of things that you can evict people for, and I'll just go through those real quick. So non-payment of rent, that's obvious. Violation of the rental agreement, that can be a lot of things. Subleasing, engaging in a business out of the property if it's a residential property. There's all sorts of stuff that goes on with that. Damage to the rental unit, if in legal jargon it's called wasting, laying waste to the property if they're not taking care of it, if they abuse it, that sort of thing. Disorderly behavior or disturbing the peace, creating a nuisance either with the neighbors in the neighborhood or with other tenants. Refusing to renew a lease or rental agreement of like terms and conditions at the end of a lease. That's a grounds. Refusal to provide access to the apartment or the unit when requested in accordance with law. That's also a reason that you could eject somebody. And unapproved subtenants in the property. And criminal activities, obvious, if they engage in either manufacturing drugs or selling drugs, or if they're using it for other unlawful purpose, that's a reason for an eviction. So there's a lot of things that fit into that category. So what happens if you find yourself in a situation where you have a tenant that falls into one of those categories? So we'll break this down step by step. So let's go with the easy example of a tenant that stops paying rent. What do you do if your tenant stops paying rent? So the primary thing to do, or the first thing to do, is to give them what's called a 3-day notice to pay or to quit. So that means that they have to either pay the rent, bring it up to date, or they have to move out, and they have 3 days to do that. That notice has to be in writing, and it has to be properly served on the tenant. So there's lots of forms out there for that. It's pretty simple, but it's really easy to screw up. So if you haven't done it, or if you don't have any experience, you should get somebody that can help you put that together. That lays the foundation for your unlawful detainer action. There's also a 3-day notice to cure or quit, and that's in a situation where somebody's engaged in unlawful activity on the property, or they're breaching the lease. You say you have 3 days to either quit what you're doing or you need to move out. And then there's other notices, 30 and 60 days for what's called no-fault evictions. If you want to convert the property to another use, or if you want to use the property yourself, you can use those 30 or 60-day notices. So those are no fault. So this is this stage, doing this notice is where a lot of the mistakes occur. So there's a lot of different ways to screw up the 3-day notice. Either you give the wrong notice, it's characterized incorrectly, or you have incorrect amounts included in the 3-day notice in terms of the amount of rent that's due, or you include items that aren't appropriate, like late fees and that sort of thing in the 3-day notice. That'll mess up the process. So you want to make sure that you get the proper form, and you want to make sure that you fill it out appropriately. Okay, so let's assume that you have gone through this process. Your tenant stops paying rent. You fill out your 3-day notice. That 3-day notice is properly filled out. You have the proper amounts. Now what do? Now you have to actually serve this on the tenant. And the best way to do that is to hand deliver the notice to the tenant. If you knock on the door, hand them the 3-day notice, and say, here's your 3-day notice. You're behind on the rent. I need you to come up and be current on it. Here's your 3-day notice. That's the best way to do it. If the tenant isn't answering the door, or you can't get the 3-day notice into the hands of the tenant, you can also serve that on an adult at the property. If you serve it on someone who's an adult at the property but not the tenant, you also have to mail that notice to the tenant, which is a little bit more complex, but it's doable. Now, if you can't get an adult at the property, and you can't get anybody to answer the door, they're evading service, you can also post the notice on the door and then mail the notice to the tenant. So the 3-day notice starts running the day after you actually mail it. So if you go to the door, you knock on the door, they don't answer it, you do your best to get them personally served. You can post it on the door and then mail it that same day. The 3 days starts the day after you mail it. So, and then that'll suffice as proper notice. So what do you do after you serve the notice? So your tenant stopped paying rent, gave him a 3-day notice, properly served. What do you do then? So you have to wait for the 3 days to elapse. Then the tenant has to perform, or if they don't perform, then you can move on to the next step. But let me just back up a little bit. After you serve the 3-day notice, it's important to make sure that you fill out a proof of service of the 3-day notice. And the 3-day notice, so when you go to court, you have to show the court that you actually properly served the 3-day notice. So what you need in that, on the proof of service, is the name of the notice that you served, the date that it was served, and then if you had to serve it on another adult or post it on the door, the date that it was mailed. And then you file that with the court, and then the court's satisfied that you properly served the 3-day notice. That puts the ball into the tenant's court. So now the tenant's sitting there with a 3-day notice that says, pay me the rent or move out. So they have two options. They can pay the rent or they can move out. Well, actually, they have 3 options. They can pay the rent, move out, or they can do nothing. If they do nothing, then that puts the ball back into your court. All right, so the next step then is to file an unlawful detainer lawsuit. So if they don't comply with the notice and they don't do anything, your job is then to go file an unlawful detainer complaint. Now, you can get these forms online. You can file your own complaint if you like. They're designed to be self-explanatory, but good luck with that. Take a look through them and see what you think. There's a lot to them. There's a 1,000 ways to screw them up. But you can do it yourself. You can pull up the forms. You can fill them out yourself. They might get bounced back a bunch of times.
Okay, I don't know if it's just me, but I don't know if you're sticking for me or if you're sticking for everybody. Hold on one second. Okay, David, you still there with us? Kind of froze up on us there. He's frozen. Okay. So we'll give his internet a second here to catch up. and hopefully we'll get you back here. David, you still frozen, okay? Looks like we got a little activity there. All right, he's connecting back in. Thank you everybody for being patient. All right, I see you there. Are you?
Did I lose you there?
Yeah, you froze up there for a second for some reason.
Okay, where did I leave off? What was the last thing you heard?
Um, Gosh, I think it was just how it's easy to mess up serving 3-day notice.
Okay, that,
But you've been saying that for a long time, but
yeah,
yeah, like that's really
yeah, yeah, it's all easy to mess up. Okay, so did you hear anything about my stuff with the filing of the complaints?
not yet. Well, I'm
Hmm.
not sure. Go ahead and start. Yeah, that I probably we don't. I don't think we heard that. So yeah, go ahead and maybe start there.
Okay, so we'll just I'll go back to that. So if you do get your 3-day notice properly served, and the tenant does not perform, doesn't pay, or get out, then you got to go on to the next step, which is the unlawful detainer lawsuit. And there are forms that you can get from LA County that will allow you to fill in the blanks on those things. They're supposed to be self-explanatory, but they're not. So good luck with that if you do it yourself. It's difficult enough for people that have done it all the time to get it right and to get it done the first time. So I would suggest that you get help doing that. You'll need an unlawful detainer complaint form. You'll need a summons that has to be filled out properly so that it can be served on the tenant. And then there's cover sheets that you have to fill out. So if you get those done and you get them properly put together and you get them past the court clerk and the court clerk gives you a stamp on it, then you can take those and you can serve those on the tenant. That's the unlawful detainer complaint and the summons. Those are the things that show up in the index. If you do a search on a tenant, if you do a tenant screening, what will show up on a tenant screening in an unlawful detainer index are the summons and complaint for the unlawful detainer case. So that's what's going to show up. Then you're going to be able to see where what properties were involved, who the landlord, who the parties were. That's what shows up on the radar when you serve a summons or when you file a summons and complaint. So if you get to that point, then you're in the litigation process to get them removed from the property because they're not doing it voluntarily. So you have to have that properly served on them. That's going to require something a little different than serving the 3-day notice. 3-day notice you could serve yourself as a property owner. Not so with the summons and complaint. You have to get a registered process server to do it, or someone else who's over 18 years old who's not a party to the case. They have to serve that on the tenant, and the tenant has to be personally served, either at home or at work, or you can subserve it, which is similar to the service on the 3-day notice where you serve an adult and then you mail it to them later. So let's just assume you get all that done correctly and the tenant is served with a properly filed summons and complaint, and they now have the opportunity to respond or not. So they have two choices. They can respond to the complaint or they can not respond. If they don't respond within, now it's 10 days. It used to be 5 days. They used to have to respond within 5 days of the date that they were actually served. That was just increased to 10 days. So if they don't respond within 10 days, happy days, they default. You can go to the court and file what's called a request for entry default. And then that moves the process forward. If they do respond, then you're into the litigation process with the tenant. Now, in LA County now has a right to counsel for tenants, which means that they can get a lawyer to represent them at no cost to fight off your attempt to remove them from the property, which is distressing for most landowners, and for obvious reasons. Lawyers complicate the process on the other side. representing tenants. So how do you? So who gets free counsel as a tenant in LA County? So what they have to show is that they live in unincorporated Los Angeles County, that they're low income, and that there's a threshold that they have to meet. They have to sign a declaration on that, and they have to have an active case filed against them, active eviction case. So if they can show that, then they can get a lawyer to represent them. And when that happens, so lawyers are generally creative people, and they make things harder than would otherwise be the case. So if you have a lawyer on the other side, you can expect to have several different defenses launched against you. Even if they aren't based in reality or fact, they're probably going to get alleged against you in defense of a landlord-tenant action. So now they don't necessarily have to prove them up at the point that they allege them. So that's going to mean that you have to get into discovery with them and go through that. But here's some of the stuff they'll throw up. So they'll say that the tenant wasn't given proper notice, even if they were given proper notice. They'll challenge the notice. They'll challenge the way it was served. They'll challenge who served it. They'll challenge whether it was mailed appropriate or not. That creates delays. They'll allege that if they didn't pay the rent or they didn't pay the full rent, that the reason that they didn't do that was because there was a defect with the property, like a leaky roof, or they didn't have heating for a period of time, or they had pest problems or peeling lead paint or something that the landlord didn't fix within a reasonable time. They'll throw that up there. They'll also throw out if you're in a city like Los Angeles that has a whole bunch of different requirements, they'll raise the affirmative defense that you didn't follow the eviction procedures properly, and that it wasn't that the filing should be dismissed because you didn't do what you were supposed to do as a landlord. So there's a whole bunch of different things that they can raise at that level, and that slows things down. You have to then do discovery on it, and you have to refute those affirmative defenses at trial. So if you go to an unlawful detainer trial, and they are making a defense that, hey, you didn't take care of the property, you're going to have to put on evidence that shows that you did. If they say, hey, I didn't have heat, you have to show that they did have heat, or if they lost heat, that you adequately addressed it and that you did it in a timely manner, and that there's no basis to say that you are, not doing what you're supposed to be doing as a landlord. So that will show up. So if a lawyer shows up on the other side for the tenant, that's generally not a great thing, although it's not fatal to your case. You're going to have to do a lot more work, though. So if you're in LA County and you're renting to lower income people, that's something that you're probably going to come across. There's also the CCP 1179 defense that has been out there for a while now. That's the COVID stuff. People are still raising that as a defense that due to COVID, they lost income, or they have to take care of somebody, or they have to take care of dependents, or that they have health impacts. That's also an affirmative defense. And if they can prove that up, then you essentially cannot remove them from the property. All right. So what happens? What's the next step? So either let's drop back a little bit. If they did not,
and David, on that last thing that you just said,
Yeah.
is that specific to LA unincorporated? Or are you speaking for the entire LA city about the COVID as an affirmative defense?
That's LA City, and I
Okay.
believe it's also, it might actually be it's farther than that, because it's a code of civil procedure, so it applies statewide. So
Okay, great, thank you.
yeah, and that's still rearing its ugly head, even though COVID's been over now for quite some time. So there's lots of ways to slow down the process if you're a tenant, but if you set up your business correctly, you can address these before they show up, and hopefully you can make it through this without having to do too much work. But that requires a lot of pre-planning. So all right, so I hope that addressed what you were asking there, Jeff.
Yeah, and that one right there is another live stream for you to do. how to set it up.
Yeah. There's about 10 live streams that can
There we
can
go.
operate.
Well, let's do it. Let's
Yeah,
do
we'll do it.
it.
So yeah, this is just the real basics. So, but so if the tenant does not respond, happy days, you can seek a default judgment, and you'll get your writ of possession that you then send to the sheriff, right? If you go to trial and you win, which you should if you did it right, then you can also get a judgment from the court that gives you a writ of possession. So once you get the writ of possession, and here's another subject that's can probably throw off a bunch of different live streams. You send it off to the LA County Sheriff, and the LA County Sheriff is supposed to post it on the property. And that gives the tenant 5 days to move out or they get locked out. Now, in practice, the LA County Sheriff is not posting those things lickety split. They are way behind on that. And there's also some talk about the LA the city council and the county intentionally slowing those things down to keep tenants in their properties. So
what you're saying there is that the LA City Council is advising the sheriffs to move slow walk those, or
yeah, I don't know if I'd go that far. It wouldn't surprise me if that came out, but it certainly looks that way. And there's some noises from the sheriff saying, "Hey, we're doing what we can," kind of wink, wink. It's hey. I suspect there's something going on behind the scenes. LA wants to keep people in their homes. I get that. But at the same time, they're doing things that increase the cost of keeping people in their homes to landlords. So, whether or not they're actually doing that or whether you could actually show that they're doing that, who knows? But that's what everybody's suspicion is. And it would not surprise me in the least if that came out. I think the LA sheriff has said words to that effect, saying, "Hey, I'm doing all I can do here," and they're not putting a lot of people on the details to post these notices. So they're out there like 1, 2, sometimes 3 months before you can actually get your writ of possession posted, which gives them 5 days to move out. So that increases the time frame.
Sorry to throw you off on this. That's a question that I get a lot. How is that constitutional? Isn't that, just to prolong and delay like that, is that not unconstitutional? Like, there's been some crazy stories, like real psychopaths that really, like, they should be evicted and they're just waiting on that lockout forever, and they're just endangering the rest of the renters. So do you see any path? I mean, I've asked our constitutional attorney, do you see any path or any way to get that time shortened, or what could be done to shorten that time?
Yeah, I think it is unconstitutional, especially if it's intentional, especially if it's designed to prolong, the statutory period, because the way the law is written, it recognizes that possession of property is essential and critical. And if the law is put in there that accentuates that fact, says, hey, we understand that possession of property is critical. That's why we're going to make this a summary proceeding. That's why we're going to give trial preference. That's why we're going to do all these things that are designed to get possession back to the owner. If then you're stuck in a system where it says that's all well and good, but we're going to slow you down over here because we're just going to drag our feet on this. We're going to slow play this over here. And you can get all the due process and, quick response from the court that you want. But when it comes to actually posting that notice and when it comes to actually locking people out, we're just going to just not do it quick. So I think that is unconstitutional. Challenging that is a challenge on its own, because you'd have to develop the case to establish that, which you can see how that would be difficult to do, especially if they're doing it under the radar. But that's a complaint that, you know, that we get a lot. It's like, okay, hey, I got my writ. What's going on?
Yeah.
I
Well,
got a
anyway,
writ that says,
sorry to take you off track there. You'll have to introduce AOA to another constitutional attorney, someone that'll take that and help us develop that one, because man, everybody's suffering with that. But I'll let
well,
you
I've done
take
a
it
fair
back.
bit of that myself, you know, and I'm writing some articles on that as well. Like I said, we could do
Yeah.
a whole other thing on that. But yeah, it's a big problem. Um, you know, great, you got your writ of possession. See you in 3 months. You know, that's not right. And it doesn't help tenants, and it doesn't help property owners, because it makes it harder for property owners to provide shelter for people. That's what it does. And if the goal is to provide as much shelter as we can for as many people as we can, then that's not helpful. So, all right. So that's essentially the unlawful detainer process. There's a myriad of ways to mess it up. There's a myriad of ways to lose what would otherwise appear to be an easy case. You think, okay, they stopped paying rent, I want my property back. It's like, okay, well, you know, the government puts a bunch of hurdles in front of you to get your property back, get possession of your property back. So you want to make sure. So just to recap real quick, you want to make sure that you do that 3-day notice properly. You want to make sure that you get the amounts that are in there correct, and that you don't put improper amounts in there. And you want to get it served quick. And there's no reason not to get this done quick. You can always sit on it, but if you don't serve the thing, then you have no basis for bringing a suit. So I would say, if somebody is behind on their rent, and you talk to them, see what you can do. It always makes sense to try to do stuff on an informal basis if you can. But if you can't, get your paperwork done and get it done right, and get it served up properly. And then get someone who knows what they're doing to help you to get through the process. Because if you don't, it delays stuff. If you get into the process and you haven't done it right, it'll get dismissed. They'll bring up 1,000 defenses to what you're trying to do, and they'll win. And there's a lot of judges out there. There's a lot of jurisdictions that'll remain nameless at this point that are not, they do not favor landlords, and they will look for any reason to knock your case out.
So tell me, I don't know if you've read the Checklist Manifesto book. Are you familiar with that one?
I've heard of that. I haven't. I'm not
So,
terribly familiar.
just the process, having processes in place. Do you have a checklist for what it takes to serve just the 3-day notice?
Yeah.
You probably
Yeah.
do, right?
Yeah.
Able to share that with us?
Oh, sure. Yeah. You know what? I'll put that up on our website. I don't know.
Because I think people are really looking for just the practical step by step, just so that they don't miss something. And like that checklist would be really valuable for the members, I think.
Yeah, we'll definitely put that up on our website, and our website should be up there. If not, I can give it at the end. But it's SoCalEvictionServices.com, all one word, no spaces.
Okay.
SoCalEvictionServices.com. So we'll put that up on our website. Also, there's some other surprisingly good resources that you can use. LA Superior Court actually has a pretty good unlawful detainer information site, and it's written in lay terms, and it's pretty good. It's very informative, and it gives you access to different forms that you can fill out. Now, again, when you start into the process, it sounds all easy, and then you get into it and you go, I don't know, what do I put in this box? What do I put in that box? How much, it turns into a thing. So, but it's good to look at it and get a good overview of it. So
Great. Well, we do have a bunch of questions here, and do you
Sure.
have time to stick around a little bit and answer questions with us?
Yeah, you bet.
Okay, great. So, Van Nuys Apartments, please explain at-fault eviction filing with the LA Housing Department, like that
Yeah,
process.
yeah. So at at fault would include non-payment of rent, breach of the lease, um, that sort of thing. LA City requires um, that when you file a 3-day notice, or that when you serve a 3-day notice, that you also file that with the LA Housing Department.
Yeah. So,
With
what specifically do you need to give them?
You have to fill out the proper form, and you have to. It depends on the situation with it. Um, some some of these are going to be very fact specific, so we can. I'll be happy to talk to anybody. I don't. You know what? I'd be happy to talk to anybody about what their certain situation is, and if they need help filling out something, I'll be happy to help them fill it out.
Awesome.
The 3-day notice, that sort of thing.
Great.
Um,
All right, Kevin here. What notice do you serve for criminal activity, gang activity, marijuana use? Um, I'll stop there because then there's other stuff that'll be in a different category than gang activity and criminal
Yeah,
activity.
that would be a breach of the lease. So that would be a notice to cure or quit. That would be a 3-day notice. So if let's say they're doing a marijuana grow, or they're manufacturing methamphetamine, or they're selling out of the property, that would be a 3-day notice to cure. Like, stop it now or get out.
Mhm.
Uh,
And with that, do you report that to police before? You would report that as soon as you know that you would report that to the police, right? A meth lab?
early, early and often. Yeah.
Yeah. Okay.
Yeah, because one of the problems with illegal activity like that is that you could get your property confiscated from you, and the federal government will confiscate your property if it's involved in crime and you know about it.
Hmm.
So, and some people say, well, gosh, I'm not going to go out there and tell the feds or the state that it's involved in criminal activity because I don't want my property to get taken away, which is that's something you have to worry about. But I would definitely um, take measures to get them to get the police involved and know that you're not involved in this,
Hmm.
right? My property, but they're in breach of the lease, and can you please arrest them, get them out of there? And it's easy to serve somebody who's in jail. You know where they are,
Right.
right?
And with inoperable cars, it's going to be the same thing. That's a 3-day cure or quit. And you want to document the stuff with videos, pictures, I would imagine.
Yeah, and you want to make sure that you have that sort of stuff in your lease, so it's specific, in terms of what you can and can't do. No inoperable cars,
Yeah.
no
All
parking in
that's in the
spots that aren't.
AOA. It's all in the AOA lease, so it should be good.
Yeah.
Okay. Do you have recommendations for eviction services lawyers in Northern California landlords? So Alice, hey, good to have you with us. There are several. You could go to AOAUSA.com. Like if you're a member, Alice, you get the magazine, and in the magazine there's a section. Um, Let me pull up a magazine real quick. Grab one of these real quick. Like here's the magazine, just in the front page. It'll list it by services, and if you just look up evictions, you'll be able to, there'll be a whole list of companies that are there. And the companies that are advertised in the magazine, we have a kind of like a database and we keep track of complaints and things like that. But I know Beckman, Feller, and Chang is one, and another one is Shepherd. So those are two that come to my mind right off the top of my head and that have advertised with us for a long time and should be able to help you. In Northern California, it's kind of a broad, but Shepherd's more Oakland and Beckman Feller and Chang is more Alameda and actually the seven county area there. So I hope that helps. Okay, Kevin, can you serve a tenant for non-payment early on before reaching the LA city threshold? Like, I think they would know that that's a no, right? So there's no,
Yeah, that's pretty much a no.
yeah. Tell them, where do they find the what the threshold is for the before, what's the financial threat, the dollar amount threshold?
Oh,
The,
for the tenant to get legal aid.
yes.
You know what? I'm
No,
not
no,
sure
no,
what the
not for them to get legal aid, but to evict. So like they want to evict, the tenant had, because the tenant didn't pay rent, but it's below the threshold. So where do they check to find the threshold?
Yeah, that would be LA. The housing authority would have that, I'm sure, on there. I'm not sure what that threshold is just off the top of my head.
Yeah.
Um,
Yeah, and HUD has it, and yeah,
yeah,
they determine that. So, and then I think it's on the notice, actually. There's a tenant's rights notice that has to be posted in a conspicuous location. I think it might even be right there on that. And then that does change here now and then. It seems like
it changes. Yeah,
it changes like twice a year, unfortunately, but we have those. You can order them. It's 2 pages, and we basically put it into one and we laminate that, and you can pick that up. And at the trade show, we'll have the freshest version that's out, and it'll be laminated, and you won't have to pay. We'll eat the wonderful sales tax, and you obviously don't have to pay for shipping because you're there, so you could pick that one up if you need it.
yeah.
Okay, Giorgio. I heard that as soon as you start the eviction process, you can't collect the rent going forward. If the eviction takes 1 year, does the landlord lose a year of rent?
Mm. It's not that you can't take the rent. It's that if you do, it messes up the case. So you have the option of either taking the rent. If you take rent while the case is pending, then they're going to bounce your case. So
So
yeah, if
how
it takes,
would that be for just non-payment of rent, or even if it's a cure or quit?
well, no, cure or quit's different. So they're engaged. So presumably they're paying rent. They're just engaged in unlawful activity or in activity that's in violation of the lease. So um, uh, if you're throwing them out for something other than non-payment of rent, I mean, I would take the rent if they were paying
Mhm.
it. Like, I'm going to throw you out because you're engaged in criminal activity. Um, but
So
if it's for non-payment of rent, then if you take the rent, then it changes everything because it
got it.
changes,
Okay.
you know. So, but yeah, if you're sitting there for a year and they haven't paid rent and they're not gonna pay rent, if they say, "Here, I'll give you $50 or $100 towards the rent," I wouldn't do it
Mhm.
unless they say, "Hey, here's all the money that I owe you." And it's like, okay, then you decide if you want to do that. Um,
So
you know,
Cami here, she has a question. So, in the lease, it talks about being able to um, have a physical inspection.
right?
You got to check the smoke alarms and things like that. So if they if a tenant refuses that inspection, does that constitute an eviction?
That would create a basis for a 3-day notice because
Okay.
you're entitled as a landlord to make reasonable inspections with reasonable notice, usually 24 hours. And if you do that and they refuse to allow you access to the property, that would give you the basis for removing the tenant because God knows what's going on in there, right?
Right.
Um,
And we have Holly here. Once a tenant's evicted, how can we get the back rent that's owed? And I'm assuming you guys do collections. Do you do collections or no?
you don't, well, not as a part of the unlawful detainer. That would be a separate agreement.
Right, a separate deal, like separate
Yeah, it would be a
for
separate
that as
deal.
well.
It sort of pushes it into it, so the the part of the unlawful detainer that's possession of the property is summary. They call it a summary.
Hmm.
Uh, now we could get involved in helping to collect um, a judgment based on the lack of payment of rent, depending on how that shakes out. A lot of times, a tenant who isn't paying rent can't pay rent, so you could get yourself a money judgment. That sort of pushes it, once you have possession, it sort of pushes it into the standard litigation area where now you're suing for money. So that could take time, effort, expense. And then, if you get yourself a judgment for money against someone who hasn't paid rent, you know, now there are people out there that have money that just don't pay their rent. So if you can get a hold of assets or, you know, other things like that, or they have a job and you can garnish wages, you can go that way too. So
Right. In AOA, we do have a service, like you may be able to help them out if you aren't able to help them, or if the attorney that they're whichever attorney you're using, ask them if they can try to collect on that. And what happens is when you send somebody to collections, a demand letter is given to them, and then they have like 30 days to dispute that. But that goes up on their credit report with like TransUnion and Experian. So that goes up there pretty quick. And then that collections agency or the attorney that does evictions that also does collections will try to collect on that. So you're really doing a disservice to yourself and the whole housing provider community if you don't send them to collections. So we highly encourage that. We have a kind of like an affiliate program with a national company, and they tout to have the best collection rate. And whether that's the case or not, I mean, I think a local attorney can collect just, maybe able to collect just as good, if not better. But with those, usually it's kind of like you're splitting it 50-50. So if you can collect on your own, that's better. But
yeah,
it is important to hold them accountable, and that they can go for that. And the company that we use, they do not require you to have a judgment. If you show proof, substantiate your claims with your rental agreement, and like how much they owe, if there's other things that are owed, like if you can substantiate those claims with evidence, they will they'll put that up there, and they will go for it. So that's something that you can do through AOA. When you log into your membership account, there's a resources tab, and under that resources tab, there's a lot of different things that are nested, but one of them is the debt collection. And so we would encourage that for sure.
yeah, definitely. And the other thing that impacts too is, like, you know, like, which is tangential to that, is in the tenant screening process. You want to be able to see
Right.
if they have situations like that. And one of the things that tenants will try to do, especially if they have a lawyer, they'll try to settle and with an agreement that you seal the case, so it doesn't get indexed as a UD case, or that their credit rating doesn't get hit on it. So what you're doing, if you did that, that might be expeditious in the short run, but what you're doing is you're sheltering them, or future landlords, from the knowledge that these people are not good tenants. So I think if more landlords actually did pursue stuff, it would be a better thing, because then it puts
Yeah.
these people on the radar, and then you can make the decision if you want to rent to them or not based on what their credit history is, or poor credit history. So I don't, generally it's like, yeah, it's a good idea to do it. I wouldn't, collecting is a, collections is a whole other thing, but there are people out there that do it, and they do it well, and
Yeah.
they're successful at doing it. So,
Right. These
and you
guys
don't
that,
need a judgment to do it, just like a
yeah.
credit card doesn't need a judgment against you to
Right.
send you to collections for non-payment. So,
Yeah, and these guys we're using, that's all they do. So they don't eat if they don't collect. So
yeah, there you
that's kind
go.
of
Yeah, that's it.
that's motivating. So
That's a good
that's cool for
motivating factor.
them.
Yeah.
If an eviction goes to trial, so this kind of dovetails, because these are business decisions, and some people are just saying, I'm going to go bottom line, I'm going to settle instead of having a crazy attorney fee. So this question is, what's the ballpark total cost to the landlord if an eviction goes to trial? And I know that there are so many different
Yeah.
situations, so maybe a range or something would be in order.
Yeah. I mean, depending on how it goes. I mean,
Let's just call it a non-payment of rent, and everything's clear cut and there's no habitability issues. Everything's been served properly. What are we looking at? Maybe
Yeah,
that'll give one
that's
case, and they can call you for their specific. They can call you, but let's just
yeah,
say something like that.
that's that's like probably $3,000 to maybe 6 or 7 grand to get that
Okay.
through.
All right.
And that's if it's not a jury trial. If it's a jury trial and you're there picking a jury, yeah, it could take you 3 days to pick a jury, depending. So, usually we charge by the hour for that sort of thing. So, um,
So if it's
so
jury
that can vary
trial,
wide.
you if it's a jury trial, you wince and don't even want to tell us what that'll cost, huh?
Yeah. Now that's generally a lot of times that's a bluff because the other side doesn't want a jury trial either.
Mm-hmm.
But they'll throw that out there as a bluff and try to get you to back off. It's like, oh, I don't want to. I've tried jury trials before. It's a pain in the butt and it takes time. But it's like, okay, if you want to put this in front of a jury, I guess we'll put it in front of a jury. But
Yeah. So Nancy, oh, excuse me, go ahead. Sorry.
no, I mean you can see how that can get expensive fairly quickly. So
Yeah. Yeah. And so Nancy, she's asking if can you sue the tenant to collect rent for the time period where the rent can't be collected? So it's still kind of the same question about back rent.
yes, you can. Yeah, I mean, you had a contract, you had a lease, they agreed to it, and they breached it. So yes, you can definitely sue them for the amount of the back rent.
All right. So Tai here. I know that when you serve a notice for non-payment, that we are not obligated to accept any amount less than demanded in the notice. What if they make a partial payment online, invalidating, thus bringing the amount delinquent below fair market value?
Yeah, I imagine there's probably a way to reject that payment. Um, that's probably what I would do is reject it. Whatever service you're using probably has a way to reject payments. So that would,
Yeah. Well, I mean, if they're on a direct deposit, then there's no way to prevent it. And they did say here, their last little part is, I understand turning off online payments is problematic legally. Is there any basis to that? Where
turning it
yeah.
off. I wouldn't
So
say that
like
would be.
if you have a tenant portal and as an owner, you just deactivate their ability to pay rent, is that a problem legally? Have you heard of that?
No, I wouldn't think so, especially if it's not in the full amount. I mean, because
Yeah.
it's, you know, yeah, I
Okay.
mean,
Yeah. So
I would find
yeah.
a way to return that payment is what I would do.
Just return it right away, right?
Yeah, just return it right away and send them a notice that says thank you, but I can't accept this unless it's the full amount.
Right. And I'm along with you. I don't know that it is problematic legally to disable their ability to pay rent or to return. I haven't heard that before. You may know something that we don't know, but I just hadn't heard that yet. So
Yeah, I'd be willing to hear whatever
yeah.
whatever issue that they had on that.
Okay, so Nancy again. So you can collect for a case of violation of lease and nuisance. So yeah, you can be collecting the rent. That's what you're saying there, right?
Yeah, because they're engaged in a nuisance, but
Mm-hmm.
they're still paying the rent. It's like, okay, the basis for terminating the tenancy is not non-payment of rent. So paying the rent doesn't affect it. It's like, okay, you're engaged in illegal activity and you can't. So
Mm-hmm.
you have to stop engaging in illegal activity. It's not like if you have a drug dealer in your house, in your rental unit, and they keep paying you the rent, that you can't throw them out because they're paying the rent. It's like, well, they're selling drugs. So
Mm-hmm.
we're going to throw you out because you're selling drugs, not because you're not paying the rent.
And then Holly here, small claims court for back rent owed. So again, same questions coming up here.
Yeah, you could do that.
So you can do that, but you don't necessarily have to. If you just take them, if you put them to collections, you don't even necessarily have to do that.
Yeah, I would sooner send them to collections than take them to small claims court.
Mm-hmm.
I mean, get a professional helping you to collect your money. If you go to small claims court, first off, you're going to have to present your case. You can't have a lawyer present your case for you in small claims. So you're going to have to spend your time and effort doing that. And that may not be difficult to do. You show them the lease and say, hey, this is what they, what they agreed to, and this is what they didn't pay. But it seems to me to hand it over to a collection agency. Now you're going to take a hit, fee wise. They're going to take their, chunk of change,
50%.
but you're not doing anything. It's like, hey, here, this is what they owe. Can you please go collect it? And you know what? If I had to take my choice between whether I had a small claims judgment against me or I had debt collectors calling me, I think I'd probably take small claims judgment because it's going to sit there and do nothing.
Right. Yeah.
You might
Really,
then hand it to a collection agency.
sending them to collections is really it really is helpful for the whole industry, and
It is.
your
Yeah.
best. It's your best option, and not a great option. It's not 100%, right? And even
No, you don't want to be there, but it's the best of bad choices, put it that way.
Exactly. And then Mike, with our final question, constitutionality, ideas for test case. So like, what's the ideal test case in your mind regarding the takings or the Fifth Amendment or, any of this?
Yeah, I think there's some of these situations like with, there's LA Municipal Code 151 in particular, which limits, even so. I had one lady call me who wanted to get her property back because she wanted to move back into her own property. Well, her problem was she had a tenant who had been there for over 10 years and he was 62 years old. So according to the statute, she can't do a no fault eviction on him. It's like, well, wait a minute. This is my property and I want to use it for my purposes. I want to live in this property, either myself or my family. And now you're saying I can't. So that I think is unconstitutional. I think that's a violation of the Fifth Amendment. I think that's a taking. That's regulating you out of your property without compensation, even if they're paying rent. It's like, hey, you know what? I want my property back for my use, and you're preventing me from taking my property back for my own use. And if you're going to do that, then you have to pay me. You have to buy my property from me at fair market value. So my take on this is that is unconstitutional. Now, I don't know. I don't think anybody's actually challenged that yet. That's probably, that's a thankless task. But I think at some point, somebody's going to have to do that. Someone's going to have to take one for the team. And
yeah, well, I mean, we have the Political Action Committee, and we raise money. And if there's any way that we can get a lawsuit going that will challenge the constitutionality of something, then I mean that's what we save our money for. We do not pay. We don't finance politicians' campaigns. We save money specifically for lawsuits, and then times like when we had the Prop 33, where we purchased like over 50,000 of those. Prop 33 rent control. Stop that. Stop. Anyway, so those are the kind of things that we want to spend money on. And
well, I have a case that's a possibility for that, and so I'll have to talk to this lady. She had another lawyer representing her on the unlawful detainer case, which I didn't. I don't tread on other lawyers. I'm not a go swipe cases from other lawyers and stuff. But if it gets so what they had was they filed an unlawful detainer based on a 60-day notice because she wanted to have her property back, and the defense lawyer on the other side filed a motion for summary judgment saying, hey, LA Municipal Code section 151.3 says, hey, you can't get your property back if I've been in your property for 10 years and I'm over 62. And I looked at that and I looked at the code and I'm saying, you know what? They may be right, but that may not be constitutional.
Yeah,
so that's one of those things where where the court says, yeah, that's what the statute says, and I'm sorry, landlord, you can't have your property back. So it's like, okay, well, now I'm going to sue you I'm going to sue to have this statute declared unconstitutional because that's a taking.
Yeah,
That's So
All
there's
right,
some
guys.
fertile ground out there for that, I think.
We have one more. I think it's going to trickle. Do you have a little, how many more questions can you take? One more?
Whatever you like, yeah, it's fine.
Okay, here we go. We have Noel. I'm an owner, occupy, eviction in LA. I returned rent, paid relocation, served 60-day notice, and filed UD. Tenant refuses to leave and threatens legal action. Can this cost me more than relocation?
Yeah. I mean that that's the short answer. Yeah, I'm sorry to hear that. But yeah, you know, I've
So
seen
there's
that.
this phone number, 818-495-5952. Is that right?
Right. Yeah, give us a call.
Man,
Yeah.
it stinks. And if we can do something about it, we will. We're all constantly learning, right? And I thought it was kind of fun to learn about just seeing with a driver's license, right? And one thing that I learned is that a real driver's license can do this, where if it's a fake one, it's gonna bubble. So
Really? Huh.
when you guys are taking your applications with those applicants, actually feel the card. There's several different features there that you can look into. I've been meaning to do a live stream on it, and hopefully I'll get around to it. It's just taking time to get the graphics done for that thing,
Mm.
but hopefully we'll get that done in the next week or two here. But anyway, guys, keep reading, keep watching, and just constantly staying updated on everything because things are changing, and the trade show is going to be a great place. I know that David's going to be there with
Yep, I'll be
SoCal
there.
Evictions, so come out and meet him. I mean, think about that, guys. You have attorneys in their booth all day long at the trade show.
Yeah,
Come and ask
ask me
questions.
whatever you like.
I don't, everybody who comes to the show, they'll ask questions with the attorneys. And I don't know anyone that doesn't leave without their question being answered unless it's, some kind of crazy.
Yeah, and in
It
that
doesn't relate to
context,
apartments.
yeah, and in that context, I can look it up too. I mean,
Yeah.
if I don't know it off the top of my head, I can spend time to look it up. So,
Hey, David, thanks again for your time.
yeah, you bet. Happy to do it.
All right, everybody. And got another live stream at 12, and then we'll be off for the 4th of July, I believe, but hopefully I'll get that one up on the on how to spot a fake California driver's license. That's kind of been a fun little research project of mine, and hopefully we'll get that going here pretty quick.
Yeah.
Okay, take care, everybody. Bye bye.
Thank you, Jeff.